Hi, class. Welcome to week 3 of environmental law. This week, we are going to be studying our first environmental statute. And the first environmental statute that we need to discuss is NEPA, which is the National Environmental Policy Act. So, we're going to be talking about that, reading chapter 3 of the textbook, looking at the PowerPoint. There's some supplementary materials and a lecture. And then for our homework is the quiz. There's a discussion board assignment. Uh, Different about this week is we are studying for our text test, which is next week, week 4. And then there is a written assignment. And again, there will be, I'll talk about that later on. So let's head on to our lecture. Okay, so the National Environmental Policy Act, that's the code section 42 USC 4321 et sec, or 4321 to 4370, and it was enacted on January 1st of 1970. And it was our first attempt as a country to form a system of national environmental policy. Okay, so Congress put out its stated purpose. One was to declare a national policy. There was never, each agency kind of maybe did some attempts to improve our environment, but it was never a national policy. And it was never our policy to promote efforts to prevent or eliminate damage to the environment, to stimulate our health and welfare, we are now enriching the understanding of ecological systems and natural resources important to the nation. And this, is just a practical thing that it did. These are kind of like more policy statements and goals of it. But we also established a Council on Environmental Quality. Okay, so NEPA declared the environmental policy and didn't just say like, hey, we're now, our agencies or our federal government is going to care and think about the environment before they do things. They actually created what we call action forcing provisions, or teeth. And I think there's one case that talks about NEPA as not being a paper tiger. It's not a paper tiger, it's an actual tiger. It does have teeth. Okay, and establishing this Council on Environmental Quality. So in practice, what NEPA does, besides the first and the third thing, it forces federal agencies to consider the environmental impact of their policies and actions before they do it. Okay, so here is our policy. It is our continuing policy to use, this is pretty drastic language, all practicable means and measures to create and maintain conditions under which man and nature can exist in productive harmony. Okay, so it's kind of declaring it as a balancing act, like we talked about in the first class. So we want to exist in harmony, but fulfill the social, economic, and requirements of present and future generations. And that's like something that, we're thinking about more and more, the future generations of Americans, and, what we're leaving and whether this planet will still be here for our children or our children's children. Okay, so the federal government is going to use, again, all practicable means. That's pretty big standard. So we're being a trustee of the environment. We're assuring safe, healthful, productive, and culturally pleasing surroundings, widest beneficial uses of the environment without degradation or risk to health or safety, preserve important historical, cultural, and natural aspects, balance and enhance the quality of renewable resources, plant trees. And Congress does recognize that each person should enjoy a healthful environment, and everyone has a responsibility to contribute to the preservation and enhancement of our environment. Okay, so it's broad and general, talks about balance, and it ensures that the environment is always looked at before federal projects are undertaken. Okay, so CEQ, I mean, it was originally supposed to be 3 people. I think it's bigger than that now. But the chairperson is appointed by president. It's a cabinet type position. And their job is to assist the president in assessing the quality of the environment, kind of act as a watchdog to the federal agencies to make sure they are complying with NEPA and suggest new national policies. So they are, an advisory board on environmental issues to the president. They don't really tell you everybody who's in the council, but they talk about our chairperson, who was recently appointed by Biden, and she is the first. Oh, she's not even just. She must not be the first woman. I don't know, but she's the first African American person to serve as this position. And, as we talked about environmental justice and environmental racism, she is focused on that, it says. So, I mean, if you want to learn more about Chairperson Brenda Mallory, look at her with her big smile on her face. She seems very happy to be there. She's from Waterbury, Connecticut, okay. So, that is who she is. Now, if you look at like priorities, that's just that's Biden's priorities. It's not the Council on Environmental Quality. But, interesting little organization. They have an internship program if anyone is interested in it. And if you want to see what they're up to, you can go to news and updates. So these are obviously, recent stuff. Oh, and I think, did I post this? I might have posted this. If I don't, I should. Well, you guys can see it. But this is like, a year's wrap up. I think it wasn't on this. I think I did. It was like on Biden, and I had the one with what happened regarding the Biden administration. But these are highlights of what the CEQ has done in the past year, which is probably aligning with what the president is doing. Oh, okay. There she is. All right. So, CEQ has changed and grown. Clinton created the Office of Environmental. Yeah, that's why it's not a 3-person board anymore. I remembered that. So Clinton created another Office of Environmental Policy, which was later merged with the CEQ, which gave the CEQ more resources. So during our prior president, this was not a priority. So the chairperson was vacant. And, I guess maybe I did attach this. Maybe this is what I'm thinking of. Too much stuff going on. I don't remember what I did or what I'm doing. Okay, so that's the stuff it's done. Okay, NEPA also assigns specific responsibilities to the CEQ, things like overseeing the Office of Federal Sustainability. Okay, so the CEQ can issue regulations, and they issued regulations that require federal agencies to incorporate NEPA requirements into all plans at the inception of the project. Systematic interdisciplinary approach required, and they are required for all federal agencies. Now, sometimes the EPA gets some leeway because their whole job is protection of the environment. Um, but again, take a gander at that PDF or that link about what the CEQ's done this year. One of the big things, was kind of this reexamination by all federal agencies of the things that they've done in the past 4 years to make sure that they're not screwing up the environment with what they're doing. Okay, so NEPA, it's all about procedure. So we're not saying you can't do anything that disrupts the environment. That's not what NEPA does. NEPA requires agencies to go through a process. And in that process, the agencies are required, to consider the environmental impact of their actions and go through a process and look at alternatives. Um, and if they go through that process and weigh the balance, then they're pretty much in the clear. So the first case we're going to talk about is Calvert Cliffs Coordinating Committee versus the U.S. Atomic Energy Commission. And so this is another one of these citizen group cases. And they claimed that the Atomic Energy Commission, the regulations that they put out did not satisfy NEPA. Okay. They said NEPA is a general mandate, has a broad delegation of authority to agencies. It does require that all federal agencies consider environmental impacts in their activity and give certain procedural measures. And so, and the citizens group is claiming that they did not, go through the proper steps. So the Atomic Energy Committee, in their defense, contended that the NEPA was too vague. So there's a lot of discretion for these agencies to do what they want, and the rules and regs that they created fell within the broad scope of NEPA. So this case, Calvert Cliffs, is significant because it is the first court review of NEPA. And remember a few cases back, the defendants were talking about this flood of litigation that's going to happen. So this was the beginning of the flood, right? The floodgates were open. And the punchline is that the court held that the Atomic Energy Commission's rules did not comply with the policy set forth in NEPA or the procedures that were required. Okay, so it talks about NEPA as a procedural rule. NEPA does allow for balancing and discretion on part of the agencies. But so even though the decision-making policy is kind of flexible, you can balance a lot of interest, the agencies have to go through the process. They have to go to the procedures that are required by NEPA, which we'll talk about after we talk about this case. You have to have a detailed statement covering the environmental impact of the proposed actions of the agency. There has to be a description of all the alternative actions that were considered. And this statement, composes, compiles, completes, consists, is what becomes the record. And the record is evidence that the agency has complied with the requirements of NEPA. The court talks about language of NEPA, which says to the fullest extent possible, they must, consider these environmental impacts. This was the court that's talked about NEPA as not a paper tiger, as an actual tiger that with teeth. And the court says, you know what, NEPA, the procedures required by NEPA, we as the courts have the power to and are willing to enforce them. Okay, so DC Circuit, who is the court here in 1971, recognizes the judicial role of enforcement in the congressional intent of NEPA. So they're saying, okay, Congress created this statute. It's up to us to enforce this. Okay, so their ruling said that so the AEC said, oh, we don't have to consider environmental factors unless it was affirmatively raised beforehand. And that was improper because NEPA requires environmental factors to be considered. That they didn't have to create their rules and regs for NEPA compliance within a certain period of time because there wasn't a timetable in NEPA. The court says this doesn't justify how long the commission's delay in adopting these rules. Said the commission has to, can't just think if somebody else is doing the work. They have to conduct their own independent evaluation, and the hearing board has to consider environmental factors in issuing operating permits, even if a permit had been issued prior to NEPA's requirements. Okay. So that was the Calvert Cliffs case. Said yep, we're all on board with NEPA. The courts are all on board with NEPA, and we are going to enforce it. You bet. Okay, so NEPA. So now we're off Calvert Cliffs, but NEPA, the applicability of NEPA. Who does it apply to? Agency actions that individually or cumulatively, oh my gosh, my mouth today, have a significant effect on the human environment. Okay, so the one way you get out of NEPA, or a federal agency gets out of NEPA requirements, is if what they're doing is classified as a non-major action. Non-major actions are not governed by NEPA. So any minor federal involvement or just like little itty bitty things that an agency is doing will be exempted from NEPA. And an agency, before they do something, like, well, I don't have to do anything with NEPA, it's a non-major action. So that, that can be litigated as to whether what they're doing is a major action or a non-major action, like the case of Norton versus Southern Utah Wilderness. So this was a case against the Bureau of Land Management, and Bureau of Land Management manages a bunch of the certain percentage of federal lands, which we'll talk about later on in the semester. And they, Bureau of Land Management was allowing off-road use vehicle, ATV vehicle use on federal land. And the Southern Utah Wilderness Alliance sought an injunction to prevent the use of these ATVs in these parklands or the public lands. So the Bureau of Land Management, it's not like a wilderness area that they're talking about. It's just like public land or federal public land. And they had remained a policy of multiple uses for these public lands. And, Congress at that point was trying to figure out which one of the, Utah, there's a lot of nothing in Utah. They're trying to figure out which is going to be classified as wilderness land, which really you can't do anything like motor vehicle wise on wilderness land. So the court held these little allowing ATVs was not a non-major action. There was no major federal action, so NEPA doesn't apply. So NEPA requires this hard look doctrine, but NEPA action or inaction, so only is where the agency either acted or failed to take a discrete action that it was required to take. So the citizen group claimed that BLM violated its management to manage this wilderness study area. But the Bureau of Land Management had a lot of discretion, and it didn't mandate the exclusion of all RV off-road vehicle use or the inclusion. So you didn't need a hard look under NEPA. There was no ongoing major federal action. So this was like NEPA doesn't even kick in because it's a non-major action. Another way to get out of, so that's the end of that case. But another way to get out of NEPA is if you have a case of a categorical exclusion. Of course, there's an acronym, CE. So those are actions that a federal agency has determined after the Council on Environmental Quality has reviewed it that doesn't have a significant effect on the environment, and so we don't have to do any of the NEPA requirements. So it's kind of it's not an administrative tool to avoid paperwork and a lot of the things that agency dues are classified as categorical exclusions in practice. Otherwise, we might just be all tied up in following NEPA requirements. So nothing will get done. Okay, so another case, 2004. So this is a lot more recent. Called Department of Transportation versus Public Citizens, Supreme Court case in 2004. Okay, so at some point there was Mexican trucks weren't allowed on United States roads. But then, this must have been Clinton, during NAFTA, they lifted the moratorium on Mexican trucks because we were supposed to have open trade with Mexico. The Department of Transportation was sued for issuing rules for Mexican trucks without an environmental impact statement. And that's, we'll talk about that in a second, but that's part of the requirements of NEPA. The Department of Transportation found a finding of no significant impact, so they didn't have to file an environmental impact statement after they had done an environmental assessment. But the plaintiffs, which is the citizens group, thought that this finding of no significant impact was arbitrary and capricious. But the Supreme Court held that really the Department of Transportation couldn't do anything. The presidential action couldn't be changed with, rules of the Department of Transportation. They can only regulate and inspect the trucks as they are. They can't do anything else. So since they couldn't, even if they had done an environmental impact statement, they couldn't act on it, it can't be required. So that's just a little bit of way of getting around it. So what are these teeth of this non-paper tiger? Winston Churchill said, plans are of little importance. But planning is essential. Okay, so first thing under NEPA that an agency has to do before they are doing a major action is conduct what we call an environmental assessment, which is also known as an EA. It's a beginning of a process to determine the environmental impact of this agency action. It's kind of like a screening. Let's do some basic fact finding to say, well, is this action going to have any environmental impact at all? So, A, do we need this project at all? Well, if we need it, and maybe there are bad things that can happen to the environment, what are different ways we can accomplish this need? Build this road, build this power plant. What are the alternatives? And then from each of the alternatives, you can talk about what the environmental effects would be. Yeah, and so the anticipated environmental impacts of all alternatives. You also, as part of your environmental assessment, have to have a list of everyone who worked on it and everyone who was consulted. It's optional. You can ask for public input on environmental assessments. Boy, this is not. I'm doing this too late at night. Sorry, gang, for the yawning. So you can ask for public input, but it's not mandatory as part of the environmental assessment. If so I've done that, done that little fact finding, this environmental assessment, and after you've done all the work on an environmental assessment and you find that there will be not that much of environmental impact by this agency action, the agency may make a finding of no significant impact. Finding of no significant impact. The acronym is FONSI. Here's FONSI from the 1970s TV series Happy Days, and he, with his thumb out. So if you have a FONSI issued, everything is cool, right? FONSI was cool. There was no environmental impact statement required. Okay, so if you've done your environmental assessment, you find no significant impact, you're done. You're cool. Okay. All right. I have an example in the module that I posted. Look at me posting stuff in the module. I think these were from FEMA. Okay, so here is an environmental. Oh, and it was about Chicago. It was about something that they were going to do on Lakeshore Boulevard. I was trying to find just examples of what these things look like for your edification. Okay, so this is, an environmental assessment. They were doing some, it's on Lake Michigan on the East Coast, Marquette County, Michigan. So they're going to do some coastal infrastructure, and they are doing an environmental impact. So they're going to relocate, they're stabilizing the shoreline, probably to prevent erosion or combat erosion. And so they go into, how many pages is this? Are they going to tell me here? When I go to the end, is there going to be a page number? That'd be nice. Well, that's page 8, but I think we're farther than page 8, aren't we? Oh yeah. Go all the way to the end here. That's a chart. These are like drawings. I just want the end of the actual text here. Yeah, and these are all the charts that they were, so kind of everything they referred to is in here. But it's pretty big, even though it's supposed to be just like an initial fact finding thing. It's not like they did nothing. There's a lot of information, and I'm sure a lot of important data in this Trimedia report. Probably some consultant that they used. Oh, that's an alternative. Remember they have to go through alternatives? That was something about one of these alternatives that they had considered. Alternative monitoring point summary report. So all of these are attachments. All right, maybe we'll just go to the table of contents, right? So our assessment, alternatives 1, 2, they're telling you which alternatives they came up with, affected environment, and so who is it going to affect? You have migratory birds, invasive species, potential endangered species, aquatic environment, all that good stuff that is considered, archaeological resources, because we have to talk about the cultural environment. Then we have the soil and all of that. Okay, but then they find no significant impact. But it's pretty comprehensive. So that is what an environmental assessment and finding of no significant impact look like. Okay, let me pull forward here. We're almost there. Okay. So you do your environmental assessment and you're like, you know what? There is a significant action. Then the agency needs to do a second step, which is the creation of an environmental impact statement, which is a lot of work. With super detailed analysis of the environmental impact of the proposed federal action. So if it's a joint effort between different agencies, one of them has to become the lead agency. The other ones would be cooperating agencies. You can have outside consultants, hired to create these environmental impact statements. The first thing that you do in an environmental impact statement is you conduct the scoping process. I think this is a quiz question, so make sure you understand scoping before you start to take the quiz. So in scoping, it's kind of like the first step of the EIS. You have to identify and address significant issues related to a proposed action, including the range of possible actions, alternatives, possible environmental impacts relating to the alternatives. It's basically you're getting the parameters of the project. What are the potential issues? What's the timetable? And it is the beginning of the opportunity for public commentary on this proposed action. Then we get so all the alternatives are listed. We get the environmental data for all the alternatives. So, and then you start the actual EIS. Okay, so then the EIS has expected environmental impacts of a proposed project. Any unavoidable adverse environmental impacts, because you're damming a river, there's going to be some environmental impacts. So what are the unavoidable ones? What are different alternatives to the proposed project? So if you have a hydroelectric dam that you're going to build, and presuming that you need a power plant, what are the alternatives? Coal, maybe coal has worse environmental impact. Nuclear, maybe nuclear has worse environmental impacts. So what are the alternatives and what are their impacts? Then you're doing your balancing thing. You have to balance what we need now versus what's the expected long-term use of the environment. What are we saving this for? So it's a balance. And what resources do we need to commit to this project that are irreversible? More stuff. Oh, it's the same slide that is duplicated. Okay. In the CEQ regulations regarding environmental impact statements, they emphasize evaluating possible alternatives. We want to, if a project has to be done, something has to be done. They want the one that results in the least amount of environmental damage. Morton's back. Everybody sues Morton. I think he was like the chairman of the Department of Interior or something like that in the 70s. So he was a defendant a lot of times. Secretary of the Interior, that's who he was, yes. So Morton sold like leases for offshore drilling rights, in Louisiana and the Gulf of Mexico. And the question is, did the agency, the Department of Interior, did they, cross their T's and dot their I's with regard to NEPA? So did they actually discuss the alternatives to offshore, oil drilling? Um, and did they just, discuss the impacts to marshland, and the results, the potential for oil pollution? So they didn't talk about what are you going to do with the debris or the sludge that comes out? Where is that going to be dumped? If you're dredging, what are the marine effects from construction and dredging? A lot of times, then, if you're dredging and putting stuff in like inland, then you have saltwater intrusion maybe into the groundwater or a freshwater pond or lake or something like that. We're in the 70s. You guys are all probably too young to remember this, but we were in the 1970s in what was called an energy crisis. We were didn't have OPEC was flexing its muscles and limiting the amount of oil and gas that they were distributing to the United States. So they were kind of trying to combat this by drilling offshore in our own waters. But so that's kind of why that was like a vital thing for us to do at the time. But the court found that the environmental impact statement has to include, if you're talking about the alternatives, they have to include the impact of these alternatives. And we had to look at this to the fullest extent possible, and the alternatives need to be exhaustive. Anything under the sun that we can think of. The standard of, the requirement as to alternatives is a reasonableness standard. And where the environmental aspects of alternatives are readily identifiable by the agency, it is reasonable to state them. So, you're basically you want to compile the record. So they have to discuss alternatives and find kind of the least impacting alternative. They have to analyze past activities in the area, present activities in the area, future activities. What are the cumulative effects of these activities? And if you can mitigate them, the environmental impact statement must talk about how. One of the funny things that NEPA says is they require that the environmental impact statement be clear and concise. If you look at Appendix B of your textbook, there is an example of an environmental impact statement, and it is not clear and concise. It's very, very long. So page 341 to 352. So there's a lot of it. And you probably wouldn't call it clear and concise. I think I have another one too posted in the module. Again, probably FEMA. Is it? Where's my EIS? It is FEMA. FEMA just had a lot of them posted, so it was an easy place to look. Oh, look at that. That's pretty. Oh, it's about national flood insurance. And it's your environmental impact statement. Right? final nationwide programmatic environmental impact statement. See, and look at what it has here. Look at all the stuff it has. I'll just look at the table of contents because it's easy to look at. Okay, background, what the purpose of this is, why we need this in the first place, what it is, public involvement and other agencies. Remember, part of the scoping you have to designate which is the lead agency and which are the supporting agencies. Here, right, and scoping meetings, public involvement, public notice, right? That's a component of this whole process. And then here's our detailed description of alternatives. From that, they come up with a preferred alternative, and that's your environmental impact statement. Okay, I'm gonna stop this video and I'll start up in a minute while I get some water.